Hello and welcome to Daily News Simplified, an answer to what, why, and how of newspaper reading. Today we will discuss the articles displayed on the screen from the Delhi edition of the Hindu newspaper dated 26 July 2019. So let us start our discussion. Now, in continuation of the discussion of the questions that were asked in the preliminary examination of 2019, let us take up this question. So, this question reads: consider the following statements. The first is that the Parliament Prevention of Disqualification Act 1959 exempts several posts from disqualification on the grounds of office of profit. The second statement reads: the above mentioned act was amended 5 times. And the third question reads: the term office of profit is well defined in the Constitution of India. Now, this particular aspect was in news in the January month in 2018. And this was related to the disqualification of MLAs of the Delhi Legislative Assembly. And this was covered in the DNS of 22nd January 2018 and was also subsequently covered in the DNS of 14th April 2018. Besides DNS, it was also covered in the February edition of the Focus magazine. And in the discussion of the DNS of 14th April 2018, we have discussed the constitutional provisions relating to the office of profit. And here it has been clearly mentioned that the office of profit has not been defined anywhere in the Constitution. However, the Constitution provides only for the provisions of disqualification based on the concept of office of profit. So if you know that the third statement is incorrect because the office of profit has not been well defined in the Constitution of India, you can easily eliminate the options B, C and D. Hence the correct answer that comes out is 1 and 2 only. Now let us take up the discussion of newspaper. This news article on page number 9 talks about a wage crisis that is going on in the Namdapha Tiger Reserve or the National Park of Arunachal Pradesh. And due to this wage crisis, the tiger conservation is being affected. Now this news article per se is not very important. However, the location and the salient features of the Namdapha National Park are important for us from the preliminary examination point of view. So in the preliminary examination syllabus, it will fall under the general issues on environmental ecology and biodiversity. Now if you look at the previous year questions, the question that was asked in the year 2015 was directly related to the Namdapha National Park. And the question reads: which of the following national parks has a climate that varies from the tropical to subtropical, temperate and arctic? And in this case, the correct answer was Namdapha because this Namdapha National Park is spread over plains, valleys and mountain tops. And that is why it has such big variation in the climate. However, if you look at the other options, you should always go and research about the options that are mentioned in the questions related to national parks. And these can be potential questions in the upcoming years. For example, if you go through the 2019 paper, there was a question: which one of the national parks lies completely in the temperate alpine zone? So this question is similar to the one which was asked in the year 2015. So first let us look at some salient features of the Namdapha National Park, and after that we will try and answer this question which was asked in this year's preliminary examination. So regarding the Namdapha National Park, you should note that it is based on the Namdapha river which passes through this national park. Further, this Namdapha river meets the river Noha Dihing river in this national park. And this Noha Dihing river, as you can see in this map, crisscrosses this national park from east to west. Further, it is located between the Dafabum range of the Mishmi Hills and the Patkai range. And in the NCERT of class 12th, which is the Indian Physical Geography, you will find the locations of various hills in the northeastern part of India, and which is basically the extension of the Himalayas in the eastern part. So here you should note that this national park is located between the Mishmi Hills and the Patkai Boom range in the northeastern part of India. Now an important tribe which is found here is known as the Singpo tribe. And in this local Singpo tribe's language, Nam means a river. And Dafa is the name of a clan of this Singpo tribe. And that is why this national park has been named as the Namdapha National Park. Now an important feature of this Namdapha National Park is that it has vegetations of almost all the biomes. So it has vegetations of the evergreen forest, the moist deciduous forest, subtropical forest, temperate forest and alpine forests. This is because it is spread across valleys, plains and mountains. And in the mountainous regions, because of the height of the Himalayas, there is presence of temperate forests as well as the alpine forest. And in the plains region, we can find the evergreen forests, moist deciduous forests, etc. And one important endemic species which is found here is the Namdapha flying squirrel. And it is endemic to this national park and is also listed as critically endangered under the IUCN's Red List. So all these facts are important for preliminary examination, and previously also in the year 2015 a question was asked based on such information. And if you look at this question which was asked in 2015, it reads, which of the following national parks has a climate that varies from tropical to subtropical, temperate and arctic? And as we have learned that this national park is spread across plains, valleys and mountains, that is why it has such huge variation of climate and vegetation. So accordingly, it lies in all the tropical to subtropical, temperate as well as arctic. However, if you look at the other national parks which are mentioned here, first is the Kanchenjunga National Park, and it lies mainly in the temperate and the arctic region. Further, the Nanda Devi National Park, it does not have presence of the tropical and the subtropical climate. Further, if you look at the third option which is given here, that is the Neora Valley National Park, it is present in the West Bengal and it is close to the Siliguri region in West Bengal. Now, this particular national park does not have the presence of temperate or the arctic type of climate. So by knowing the location and the region in which they are present, you can easily eliminate the Kanchenjunga, Nanda Devi and Neora Valley. And the correct answer comes out is Namdapha National Park. Further, in the year 2019, a similar question was asked, and this question read, which one of the following national parks lies completely in the temperate alpine zone? So the formation of the question is similar to the one which was asked in the year 2015. So you should always look for the locations of the national park and also in the climatic region and the important vegetation that is present in that national park. And here the correct answer was Valley of Flowers National Park because it is present in the temperate alpine zone. However, if you look at the Manas National Park, it has presence in both the plains as well as mountains. For the Namdapha National Park, it is not completely located in the temperate alpine zone and has variation from tropical, subtropical, temperate and arctic. And as we have learned, the Neora Valley National Park does not have the presence of temperate and the arctic type of climate. Now what you should do is that you should look at all the questions that have been asked previously in the prelims examination related to various national parks, tiger reserves, etc. And try and understand key facts related to all the options that are present in the questions. And that will help you improve your understanding of the questions and the ways in which the UPSC is asking questions. With this, let's move to the next article. Now, this article on page number 1 is related to the Supreme Court's direction in all such districts in India where more than 100 cases are pending under the POCSO Act. And these special courts should be set up within 60 days. So this will form a part of the General Studies paper 2 under the topic Mechanisms and Laws for the Betterment of these Vulnerable Sections. Now, before looking at the directions of the Supreme Court, let us understand some salient features of the POCSO Act or the Protection of Children from Sexual Offences Act. Also, in the present Lok Sabha session, a bill has been introduced for amending this POCSO Act. Now, because of the increasing number of cases of sexual violence against children, the Government of India enacted the Protection of Children from the Sexual Offences Act of 2012. Also, India is a signatory of the Convention on the Rights of the Children, which was adopted by the General Assembly of United Nations. Now, this convention prescribes a set of standards which should be followed by all the state parties in securing the best interests of the children. And all the parties to this convention are required to take measures to prevent children from being coerced into unlawful sexual activity. So, on the basis of this convention, India legislated the POCSO Act or the Prevention of Children from Sexual Offences Act 2012. Now, this act provided for various measures and to expedite the process of justice for the victims of child sex abuse. And according to this act, any person who is below the age of 18 years is defined as a child. And this act particularly penalizes any person who commits offences such as sexual harassment, sexual assault, penetrative sexual assault, and aggravated penetrative sexual assault. Also, this act aims at protecting the children from the issues of child pornography. And to expedite the process of justice, it provides for the creation of special courts. And in this line, it has provided that every district will have a designated session court, which will be known as the special court. And the state government shall appoint a special public prosecutor for every special court. And the time limit for the trial of such cases has also been defined clearly. And it provides that all cases involving child sex abuse should be completed within 1 year. And such trials should be held in camera and in the presence of children's parents or any other trusted person by the children. So this act sensitizes the process of justice, it expedites the process of justice and provides for a special mechanism for trial of such cases. Now, despite such provisions in the Act of 2012, the number of cases of child sex abuse are increasing. And that is why the Supreme Court has directed that any district which has more than 100 cases of child abuse pending will now create special courts for fast trial. And all these special courts should be set up within a period of 60 days. Now, because of the lack of proper functioning of the POCSO Act, a petition or the public interest litigation was filed in the Supreme Court. And on the basis of that public interest litigation or the PIL, the Supreme Court has provided certain directions to the governments. And in these directions, the Supreme Court has stated that there should be no excuse for long delay in the justice for vulnerable children. Further, the traumatized victims needed to be treated with compassion and kindness. Also, the CJI has asked that the government should follow a completely different approach for investigation in such cases related to the POCSO Act. Further, the court has expressed the concerns regarding the lack of infrastructure. For example, the special courts which are provided in the POCSO Act have not been created in many of the districts in India. So the Supreme Court has directed that all such districts which have more than 100 cases pending related to the POCSO Act should constitute these special courts within a period of 60 days. Also, the court has directed that there should be a support system which should comprise of qualified people who are dedicated towards child rights, and these people can act as bridge between the authorities and the victims of child sex abuse. Now, in the DNS of 11th July 2019, we have learned that the Cabinet has decided to amend the POCSO Act 2012. And in this, the new bill provides for more stringent punishments, including the provisions of death penalty for child sex abuse. And also it provides for levying of more and increased fines and increased imprisonment to curb the menace of child pornography. Now, as this is a bill as of now, and if it gets passed by the Parliament, it will become an act. So by then, it will be covered in detail in the DNS. So these were few important provisions of the POCSO Act 2012. We also learned about the guidelines of the Supreme Court or the directions of the Supreme Court regarding better implementation and speeding up the justice system for the child sex abuse, and also the recent bill which amends the POCSO Act of 2012. Now, while writing answers related to the POCSO Act 2012, you can use the directions which have been provided by the Supreme Court in the answers. So with this, let's move to the next article. This article on page number 11 talks about the representation of women in the legislatures of various countries. Now, as we all know that India has very poor representation of women in its legislatures, that is the Lok Sabha and the Rajya Sabha. So this article will fall under General Studies paper 2, again under the laws for the betterment of the vulnerable sections. Now, it highlights the examples of different countries which have higher representation of women in their legislature. Further, it discusses the reasons as to why these countries have higher representation of women in their legislature. And finally, it has suggested as to what should be India's approach for increasing the representation of women in its parliament. So first, let us look at the examples of various countries where the representation of women is at higher level. Now, according to the Inter-Parliamentary Union, Rwanda has the highest representation, which is about 61.3% in its lower house and 38.5% in its upper house. Now, the reason which is usually highlighted for this high representation of women is the law which was passed and provided for a quota of 30% reservation for women in all elected positions. However, it has also been argued that Rwanda witnessed a genocide in the year 1994. And under this genocide, a large chunk of country's male population got killed. And as large number of male population got wiped out, women's participation in the politics increased. On the second number in terms of representation is Cuba, which has about 53.2% seats for women in its top legislature. Now, Cuba does not have any law which provides for any reservation for women in its parliament or the legislature. Further, at the local level, the representation of women is very less in Cuba. Now, fourth example is that of Sweden, which has had almost 40% representation for women since 1990s. And it should be noted that Sweden does not have any constitutional clause or electoral law which provides for representation of women in its elected bodies. And finally, Nepal, which is our neighboring country, its constitution has provided 33% seats for women in all the state institutions, including the legislatures. Now, by seeing these examples, we can see that some countries have provided for reservation in their constitution, while some other countries have passed laws for providing reservation to women in the legislatures. However, if you see the example of Sweden, it neither has any constitutional clause or any electoral law relating to the representation of women in its elected bodies. And in Sweden, this increased representation is because of the initiatives of the political parties, which provide more number of women candidates in the elections. Now, if you look at the Indian scenario, India barely had 11.8% women's representation in the 16th Lok Sabha. And in the present Lok Sabha, only 14.5% of the seats are represented by women in the Lok Sabha. So this shows that the representation of women in India is very low. Now, what method should be opted by India for increasing the representation of women? Now, if you look at the example of Sweden, where the political parties voluntarily provide for larger representation of women, that system is not likely to work in India because of the patriarchal mindset of the society. And because of the lower position of women in the Indian society, the representation of women in the parliament is not likely to increase. However, in this line, the author has argued that there is a need for legal or constitutional quota which can increase the representation. In this line, he has highlighted the example of Panchayati Raj institutions where the clause for the reservation of women has been provided in the constitution itself. And this reservation clause in the constitution itself has increased the representation of women in all the Panchayati Raj institutions, including the municipalities. So in short, the author has supported the provisions of legal or the constitutional quota for representation of women in the legislatures. In this line, in the year 2008, a bill was introduced in the parliament which provided for reservation of women in the parliament. So let us look at some of the provisions and the debate surrounding that bill. Now, the 108th Constitutional Amendment Bill of 2008 provided for reservation of women in the Lok Sabha and the state legislative assemblies. And it provided for reservation of one-third of all the seats for women. Further, these reserved seats were to be allotted by rotation to different constituencies in the state and the union territories. And such allocation of seats on a rotation basis was to be determined by any authority which was prescribed by the parliament. Further, such reservation of seats for women was to cease after the 15 years from the commencement of such Amendment Act, which means that the Constitutional Amendment Act provided for the reservation of women only for 15 years. Now, what are the issues surrounding this Women's Reservation Bill? So, reservation for women in the parliament and the state legislatures has been supported by some people and has also been opposed by various sections. Now, the supporters of this bill argue that it will be a tool for improving the condition of women. And in this, they highlight the example of panchayats, which have shown the positive effect of reservation on the empowerment of women and on the allocation of resources. Now, you might be knowing that the Constitution of India provides for reservation of women in the Panchayati Raj institutions, including the municipalities. And due to this constitutional provisions, the participation and the representation of women in the Panchayat elections has increased considerably. And also, such reservation is showing positive effects in the terms of empowerment of women. Now, the opponents of such reservation argue that such a reservation for women in the legislatures and the state legislative assemblies would perpetuate the unequal status of women. And also, they say that it diverts the policy attention from the larger issues of electoral reforms, for example, criminalization of politics and the lack of inner party democracy. Further, some have argued that providing reservation for women restricts the choice of voters to only the women candidates. Further, the system of rotation of reserved constituencies for women has been criticized by some people. And it has been argued that it will reduce the incentive for any MP to work for his constituency. This is because in case of rotation, the particular seat can be allotted to a woman for which the reservation has been provided. And in all such case, the person who is the existing MP will now be ineligible to seek re-election from that constituency. And that is why it disincentivizes the MP to work for his constituency. So in this article, we have highlighted various issues relating to the representation of women in the parliament and other state legislatures. And also we have discussed the various provisions of the Women's Reservation Bill of 2008. With this, let's move to the next article. Now, this editorial on page number 10 talks about the Unlawful Activities Prevention Amendment Bill 2019. So this will form a part of the General Studies paper 2 under the topic Governance, and also in General Studies paper 3 under the topic Security. In this article, let us look at some of the proposed amendments to this Unlawful Activities Amendment Bill 2019 and what are the concerns which have been raised by the editorial in this regard. Now, according to the Home Minister of India, the objective of the proposed amendments is to facilitate speedy investigation and prosecution of terror offences by empowering the National Investigation Agency or the NIA. And it also aims at designating an individual as terrorist in line with the international practices. Further, the Home Minister in the Parliament has stated that the bill will not be misused against any individual unless the individual, including urban Maoists, engage in terrorist activities against the security and sovereignty of India. Now, if you look at the present law, it provides that the NIA should take prior permission from the respective state DGPs to start investigation in the cases of terror. Now, due to such a provision, there has been delay in the prosecution of terror cases. So, to reduce such delays, the new amendment proposes that such powers will now be taken away from the state DGPs or the Director General of Police and will now be transferred to the Director General of NIA or the National Investigation Agencies. And the DG of the NIA will be able to attach the properties acquired from the proceeds of the terrorism. Further, under the section 43 of the Unlawful Activities Prevention Act, an officer below the rank of Deputy Superintendent of Police or equivalent was competent to investigate the offences under this act. However, the new proposed amendment dilutes this power and proposes that any inspector of the National Investigating Agency will be competent to investigate offences which are punishable under this act. So previously the act provided that only officers of the rank of Deputy Superintendent of Police or equivalent were competent for investigating cases. However, now the inspectors of the NIA will be competent to investigate the cases. Now finally, the present act defines terrorist activities to include acts committed within the scope of any of the treaties listed in the schedule of the act. And the schedule in the act lists 9 treaties relating to the terrorism, which includes the Convention for Suppression of Terrorist Bombings of 1997, the Convention Against Taking of Hostages 1979, etc. Now this act further adds one of the important treaties which is known as the International Convention for Suppression of Acts of Nuclear Terrorism, which was signed in 2005. So in short, this amendment increases the definition of terrorism to include the nuclear terrorism as well. So these are some of the proposed amendments whereby the necessity to require prior permission from the DGPs of the state has been done away with. And this power has now been transferred to the Director General of National Investigating Agency. Further, to attach the properties which are acquired from the proceeds of terrorism, the approval of the state DGPs will not be required. And for this, the approval of the Director General of NIA will be required now. And also the requirement that any officer of the DSP rank could investigate the offences has also been diluted, and now the inspectors of the NIA will be competent to investigate the offences under this act. Now, although the government has claimed that they have proposed all these amendments to increase the speed of the investigation process, various concerns have been raised against such amendments. So in this line, this editorial highlights the probable impacts of such amendments. So let us look at these impacts one by one. Now, the first concern that has been raised is that the proposed amendment aims at designating a person as terrorist even before the completion of the court trial. However, the government has not clarified or set any procedure to designate any person as terrorist. And this raises the issues of fundamental rights and also increases the discretionary powers of the central government, which could be misused at times. Further, the amendments propose that any individual who has been designated as a terrorist may be subjected to arrest and detention even after he has obtained bail from the courts. This in short restricts their travel and movements and also curbs their fundamental rights. Further, if a person who was designated as a terrorist by the government is cleared by the court, even then, to remove the name of the person from the terrorist list becomes difficult because of the elaborate procedure. Further, the Home Minister in his statement in the Parliament has said that the proposed amendments will empower the government in prosecuting the urban Maoists or the urban Naxalites. However, the exact meaning of urban Maoists has not been clarified by the government in this regard. So the concern which has been raised against this is that it will provide the government a pretext against the non-sympathizers of the government who can be targeted or made to live in constant fear of being designated as a terrorist in the near future. Further, the editorial argues that the bill contains certain provisions which are anti-federal in nature. This is because the power of the Director General of Police of the state governments is being reduced, and this is being transferred to the Director General of NIA, which is the Central Investigating Agency. So in short, this is diluting the federal principles and the powers of the state government is being reduced considerably. And finally, the editorial proposes a caution and says that the government should be mindful of its obligation to preserve the fundamental rights and also should try to prevent the misuse of any anti-terrorism law. Now, this is a developing story, and further, various articles might appear in the newspaper relating to the criticism of the proposed amendment bills for the Unlawful Activities Prevention Act. With this, let's move to the next article. Now, this article on page number 11 highlights various issues with the surrogacy bill. It identifies various problems with this bill and also provides various suggestions to make the surrogacy bill more inclusive. So this will form a part of the General Studies paper 2 under the topic governance, and it will also be a part of the social issues. Now, this surrogacy regulation bill was introduced in the Lok Sabha in this month, and this was introduced with the intent of facilitating the altruistic surrogacy in the country. So in this direction, let us first understand what are different types of surrogacy and how surrogacy has been defined by this bill. Now, surrogacy is simply a phenomena where the embryo of a couple or two intending people is planted into the womb of a third woman. And this third woman takes care of the pregnancy and the birth of the child and then transfers or hands over this child which is born out of this pregnancy to the intending couple. So simply, if there is a couple in which there is one male and female, and by any reason they do not want to go through the process of pregnancy, but at the same time they want to have a child, they might transfer the embryo to a third female. And this third female rears this embryo and goes through the phase of pregnancy and gives birth to a child who is again transferred to this couple. So in this line, this surrogacy bill defines a surrogacy as a practice where a woman gives birth to a child for an intending couple with the intention to hand over the child after the birth to this intending couple. Now, surrogacies are of two types. One can be commercial surrogacy and the second one is altruistic surrogacy. Now, in this commercial surrogacy, the third woman expects monetary benefit or reward for the pregnancy. And this monetary benefit or reward should exceed the basic medical expenses and insurance of the surrogate mother. However, the altruistic surrogacy involves surrogacy arrangement where the monetary reward only involves medical expenses and the insurance coverage for the surrogate mother. So this altruistic surrogacy is only with the intention of helping the couple to have a child. However, the commercial surrogacy, besides helping the couple to have a child, also involves transfer of monetary benefits to the surrogate mother. Now, this current surrogacy bill criminalizes the commercial surrogacy because there are chances of misuse of such provision. However, it intends to promote the altruistic surrogacy. So in this background, let us understand the various issues regarding the surrogacy bill and the points which have been highlighted in this article. Now, in this bill, the purpose of surrogacy has been provided. And the surrogacy under this bill is permitted when it is for intending couples who suffer from proven infertility. It should not be for commercial purposes. It should not be for producing children for sale, prostitution, or other forms of exploitation, and will also not be permitted for any condition or disease specified through various regulations. Now, various provisions of the surrogacy bill have been provided in the PDF which is attached to this video. However, let us look at some important issues which surround the surrogacy bill. Now, for surrogacy to happen, embryos are needed, and these embryos are cultured in various in vitro fertilization laboratories or the IVF labs. And before proceeding with surrogate pregnancy, there is a need for in vitro fertilization of eggs. And that is why IVF should be discussed first, because such IVF clinics have mushroomed across the country and various malpractices are happening related to these in vitro fertilization labs. And that is why the authors have argued that before any surrogacy bill is passed, there is a need for a bill which regulates and controls these in vitro fertilization labs by the way of Assisted Reproductive Technology Bill. Further, the present bill specifies that the intending couples who can have surrogate pregnancy should be married Indian couples. In short, it does not take into account the NRI Indians who are either working or studying abroad who may want to come back and have a baby through the surrogacy. So this bill does not take into account the NRIs who may want to have child by the means of surrogacy. Now, as this bill bans the commercial surrogacy and only promotes the altruistic surrogacy, only relatives can be involved or the close relatives can be involved in such kind of surrogacy. However, this bill does not define what is meant by close relatives. Now, as this bill provides that the surrogate mothers can only be close relatives, not many women will come forward for such kind of pregnancy because of the attached stigma. And that is why it will defeat the original purpose of the bill in providing child to the infertile couples. Further, it does not include unmarried couples, for example, the live-in couples. It also does not include gay couples, single men and women. So in this line, the authors argue that in the case of LGBT couples and single parents, surrogacy should be allowed because without surrogacy, such couples cannot have children. Further, the authors have argued that the altruistic surrogacy has failed in various countries because although monetary benefits have not been provided to the surrogate mothers, however, various other forms of assistances or indirect benefits have been provided, and which is also another kind of commercial surrogacy. And further, the authors argue that the bill has been created without taking into consideration the physical and the emotional factors of the couples involved. And this is because it involves the emotional issues of the infertile couples, transgender people, single women, divorced women, and widows. And finally, the authors have provided certain suggestions to improve this surrogacy bill. So, first suggestion is to declare the surrogacy as a kind of profession. This is because the person providing a womb must have a contract which must be properly laid out. The person involved in surrogacy must get insurance, and also there should be provision of proper medical checkups. So by declaring this as a profession, things can be carried out legally. Further, there should be provision that if a surrogate cannot be found within the close relatives, the couple should be allowed to explore other options from the other group of people too. Finally, the authors argue that there are certain places where the surrogates were thoroughly exploited and it were the agents and the middlemen who did it. However, instead of removing the means of livelihood for such people, the government should have a contract that all surrogates and the commissioning parents will have to sign. So this will eliminate the need of middlemen and the agents for surrogacy. So in short, the authors have provided various suggestions to make the surrogacy bill more inclusive and also relax various restrictions that have been proposed in the present bill. Now after today's discussion, you should try and answer these questions. The answer will be displayed after 5 seconds. The first question reads, the Namdapha flying squirrel is endemic to which of the following states? Now, as we have learned today, the Namdapha flying squirrel is endemic to the Namdapha National Park and which is present in the state of Arunachal Pradesh. Hence, the correct answer is D. The second question reads, which of the following directive principles was added by the 42nd Amendment Act? Now, if you look at the B option, to organize village panchayats, it was originally provided in the Constitution. So that is why it was not added by the 42nd Amendment. The third option, that is C, the state should strive to minimize inequalities in income and status, was added by the 44th Constitutional Amendment Act. Hence, this is also incorrect. And if you look at the D, that is the state to provide early childhood care and education for all children until they complete the age of 6 years when the Right to Education Act was passed. Hence, this is also incorrect. So the correct answer is A, that is to secure opportunities for healthy development of children was added by the 42nd Amendment Act under the Article 39 of the Indian Constitution. Further, you should try and answer these questions. Answer will be displayed after 5 seconds. So the first question reads, which of the following are part of the fundamental duties under Article 51A of the Constitution? The first is to strive for excellence in spheres of individual and collective activity. Second is to pay taxes. And the third is to safeguard public property and abjure violence. Now, as we know that the second is incorrect because the fundamental duties do not involve to pay taxes. And that is why you can easily eliminate C and D. So the correct answer is B, that is 1 and 3 only. The third question reads, which of the following countries have their borders surrounding the Mediterranean Sea? So as we know that Israel, Lebanon and Syria share their border with the Mediterranean Sea. Hence the correct answer is D, that is 1, 2 and 3. With this we have come to the end of today's discussion. Now let's move on to the question for the day.